Welcome to the course on Jurisprudence 1. I am Dr. Simranjeet Kaur, Professor of Law, City University, Ludhiana. Today, we will talk about legal enforcement of the morals. So, let us start with the introduction of the topic. Legal enforcement of the moral values is a contentious issue that has been debated in the legal philosophy for the centuries. Some argues that law should be based on the moral principles and that legal rules should reflect ethical values, while other believes that law and morality should be kept separate. In practice, there are many examples of the law that enforce moral values, such as law against murder, theft and fraud. These laws are based on the moral principles that are certain actions are inherently wrong and should be prohibited by the law. However, there are also many examples of the law that are not based on the moral principles, such as law regulating business practices, environmental protections and the traffic safety. These laws are often based on practical considerations rather than moral values, and their enforcement may not be seen as a matter of moral obligations. The legal enforcement of the moral values can have both positive and negative implications for the society. On the one hand, laws that reflect moral principles can help promote justice and fairness, protect human rights and encourage ethical behavior. On the other hand, laws that enforce moral values can be seen as intrusive and authoritarian, restricting personal freedom and limiting individuals' autonomy. In modern Western political and legal thought, the subject of the legal enforcement of morality is narrower than the literal coverage of those terms. That is because much legal enforcement of morality is uncontroversial and rarely discussed. Disagreement arises only when the law enforces aspects of morality that do not involve protecting others from fairly direct harms. More precisely, people raise questions about the legal requirements to perform acts that benefit others, to refrain from the acts that cause indirect harms to the others, to refrain from that acts that causes harms to themselves, to refrain from the acts that offend others, and to refrain from the act that others believe are immoral. Answers to some of these questions may be affected by whether the relevant moral judgment are essentially religious. Subsidiary questions concern the appropriateness of the taxes adopted to discourage the behavior. The government should not forbid outright the appropriateness of the prohibition on others profiting from such behavior as when someone lives off the earnings of the prostitute, since it is rare that one argument for restricting behavior will stand by itself with no other arguments supporting restrictions. A conclusion about a single theoretical issue will not usually yield a decisive answer as to whether any particular behavior should remain free. However, a conclusion that some arguments for restraint is unwarranted can significantly affect the overall power of the totality of the arguments. For example, if someone concludes that claimed immorality of homosexual behavior is not proper basis on which to forbid it, this will substantially affect the overall strength of the reasons in favor of prohibition. Legal enforcement of moral norms against causing harm. Any comprehensive morality includes restraints against harming others. People. Murder, assault, theft and fraud are immoral. In any society sufficiently developed to have a law distinguishable from its social morality, this law will forbid murder, assault, theft, and some forms of fraud. As H.L.A. Hart pointed out, law and social morality will constrain much of the same behavior. This does not mean, of course, that the law will enforce every aspect of morality that concerns preventing the harm to others. Law is a crude instrument requiring findings of uncertain facts, with the rules backed by limited arsenal of coercive sanctions. Many immoral acts that hurt others are unregulated by the law. Nevertheless, no one doubts that in principle protecting others from harm is an appropriate task for the legal rules. Exactly what protection these rules should extend is a matter of prudential judgment or some kind of balancing of morality. Relevant factors, these plain truths may obscure some complexity that one must consider when asking if legal rules should prohibit acts on the other grounds. The idea of harm to someone else must be clarified and developed. If every unpleasant feeling or negative thought qualified as a harm as an act might be prohibited because it made some people envious or disturbed them. With such an expensive notion of harm, prevention of harm to others would justify enforcement of all aspects of morality. The most prominent procedure to begin your paper may be to select an insane case from a study that legitimately outlines the subject matter you are comprising. Approximately, maybe you have got an individual encounter that's pertinent to the subject. Otherwise, you have one noteworthy point is that anticipation of the hurt to others incorporates avoidance of the hurt that's most straightforwardly incurred on individuals as a collective. Hence, the Hart guidelines creates no trouble for a law against spying on the government. What hurts qualify as collective hurts, be that as it may, is an issue to which it is vital to return. Two related questions with respect to hurt to other influence much of the rest of the exposition. Their explanation here will clarify what takes after. Is it conceivable to create choices around legitimate control without any moral judgment at all? On the one off the chance, the ethical judgment is vital in choosing what qualifies as important. Hart it takes after that common requirement of ethical quality is suitable. In reply to the primary address, a qualification between wrongful and non-wrongful harms does include ethical judgment. For case, the judgment that enduring and weighted the mental victory of other is not important hurt. Is this sort of judgment avoidable? Is it conceivable to assume a lawful framework with directions based on an appraisal of negative results that considers as it were generally a person's inclination, joy or capacity to pay depending on no other ethical judgments, no other since choosing that as it is with inclinations. Bliss or capacity to pay ought to be considered itself a moral judgment. In case somebody conceives the grounds for the lawful control as confined in this way, would the grounds for legitimate directions appear more constrained than the grounds for the ethical judgments in common? This depends. Normal joy, utilitarianism, basical all ethical judgment on a real and imminent bliss. It would be deluding, be that as it may be, to depict their position as one in which lawful direction is decided without ethical judgment, since they would utilize the same sorts of appraisals to create or rectify ethical judgment as they utilize to decide suitable legitimate limitations. Assumes by differentiates, somebody considers that sound ethical quality incorporates numerous grounds for the judgment, but that nearly all these grounds are unessential for legitimate regulation. The recent years have provided legal philosophers with many good cases and the problems concerning the legal enforcements of the morals. The most famous are the Wolfen Report and the Ladies' Directory case, it also herein referred to as the Shaw case, which have been used as the guideposts in the debate and have been widely publicized. However, as an illustration of the fact that this question is far from settled, a freshly rendered judgment of the Supreme Court of Canada in the case of Clifford versus Queen will be used as starting point of the present analysis. It shows how just when the Parliament of the United Kingdom was acting upon the Wolfen Committee's recommendation after 10 years by repealing the criminal prohibition against homosexual acts between consenting adults in the private, the Supreme Court of Canada affirmed a judgment which not only applied in the Criminal Code of Canada concerning homosexual acts, but also interpreted its term so as to include homosexuals in the category of dangerous sexual offenders. Consequently, it sentenced the accused to preventive detention that could last for the life. In the case of Clifford versus Queen, the facts of the case were very simple. The defendant Clifford was not caught in an indecent act, but had told the police while being questioned about some other matter that had been homosexual for 24 years. He was subsequently convicted on 4 charges of gross indecency involving homosexual acts with 4 different persons. His first sentence of 3 years was later replaced by a sentence of an indefinite preventive detention. At no point was there any suggestion of violence or offences against the children or offences committed in the public, though the defendant admitted being a homosexual for so many years. All convictions against him stemmed from the private acts with consenting adult males, and the argument before the Supreme Court of Canada centered around the definition of dangerous sexual offender in the Criminal Code of Canada, as a result of which the preventive detention sentence could be administered. The final decision was Shaw versus Director of Public Prosecution, reached by a majority of the court, 3-2, based on an interpretation of the term dangerous sexual offender. The court provides that provision is aimed at a person who constitute a danger to the others, but the majority found that the court's references to further sexual offences that might be committed by the previously convicted person was an alternative element to that of the danger of the injury to the other. Mr. Justice Vortex, speaking for the majority, said, with the differences, I cannot either agree with the view that the intent and the object of the provisions dealing with the dangerous sexual offender is solely to protect the persons from becoming the victim of those whose failure to control their sexual impulses render them a source of danger, and that too apply the definition to a person who is not to be the source of danger would give the definition an effect inconsistent with the intent or object of these provisions. On the other hand, the two dissenting judges found that the court's references to further sexual offences must read as relating to the danger to the others. Otherwise, it would be tantamount to study that a person who is not dangerous must nevertheless be regarded as dangerous. It would be with the reluctance and regret that I would have found myself compelled by the words used to impute to Parliament the intention of enacting the words dangerous sexual offenders shall include in their meaning a sexual offender who is not dangerous. Report of the Wolfender Committee on Homosexual Offences and Prostitution, the legal enforcement of moral, was discussed by the Committee on the Homosexual Offenders and the Prostitution. The actual recommendations of the Committee, though relevant here, yield in the value to the actual principles upon which they tested. The Committee proceeded to define what it considered was the nature and the function of the law through extensive examination of witnesses. However, it had to admit the opinion differ so much as to what the law is or as to what is regarded as offensive, injurious and inimical to the common good, or as to what moral, social or cultural standard are, that it had to adopt standards acceptable to the community in general. Though not accepted by many citizens, the Committee has found itself unable to succeed in discovering an unequivocal public opinion, although several persons have suggested that there is a direct relationship between law and the public opinion. The members had therefore to reach the conclusion for the ourselves rather than to base them on what is often transient and seldom precisely ascertainable. The subject matter of the morality, whether sexual or not, is not always easily debatable. On the conclusion of the Wolfender Committee reflect such a state of facts, this arena is still one where the limits of the religious belief, political and social principles and behaviors had not been determined, or at least not fully investigated, and where the individuals are not prepared to state their views with the knowledge that their opinion is founded upon ascertained principles or even upon reasonable information. In the past, what was good according to the religion was accepted as socially good, but nowadays, since morality and the religion have been separated to a greater extent, both philosophers and the lawyers experience difficulties in ascertaining the public good, public order and the general moral sense, common morality. The Wolfender Committee adopts the view that the law must be acceptable to the general moral sense as determined by their own search, and the laws should not enter the field of the private moral conduct unless such conduct affects public good. On the other hand, however, the report does not supply a definition of a crime or of a public opinion. To define the crime as an act which is punished by the state does not answer the question. The notion of a crime as distinguished from the sin will therefore be based on the purpose and the function of the law in the field of morals, that is, to preserve public order and decency, to protect the citizen from what is offensive or injurious, and to provide sufficient safeguards against exploitation and corruptions of the others, particularly those who are specifically vulnerable because they are young, weak in body, in mind, inexperienced, or in a state of a special physical, official, or economic dependence. The law is the guardian of the public good and has no function to intervene in the private lives of the citizen or to seek to enforce any particular pattern of behavior. Further, then it is necessary to carry out the purposes of the preserving public order. This general concept of the law has led the committee to further distinguish between public morality and the private morality, or immorality, that is private life of individual as such. There remains one additional counter argument which we believe to be decisive, namely the importance which society and the law ought to give to the individual freedom of choice and action in the matter of private morality. Unless a deliberate attempt is to be made by the society, acting though the agency of the law, to equate the sapphire of the crime with that of a sin, there must remain a realm of a private morality and immorality, which is in a brief and crude terms not the law's business to say. This is not a condone or encourage private morality. On the contrary, to emphasize the personal and private nature of the morals or immoral conduct is to emphasize the private and personal responsibility of the individual for his own action, and that is a responsibility which a mature agent can properly be expected to carry for himself without the threat of punishment from the law. Consequently, the Wolfson Committee recommended inter alia that homosexual behavior between consenting adults in private should no longer be a criminal offense, because the so-called area of private morality apart from its own reason. The committee cites the report of the Street Offences Committee, which states that criminal law is not concerned with the private morals or with ethical sanctions. The enforcement of moral through legal sanction is not a new topic to the legal philosophers. It has in the past decades been the object of a new and through the examination. Though it is still open to the further discussions, the new morality of the second half of the 20th century will also contribute to keep the fire alive, a result of the widening gap between traditional Christian morality and the morals that modern society seems increasingly prepared to accept and tolerate. Morality implies a basic reference to the distinction of which is right from what is wrong. Various moralities differ as to extent of what is right and what is wrong, or good and bad, and therefore each community, nation, or society may have its own morality according to the local beliefs, whether social, political, religious, or other. Moreover, the expression morals and morality, though broad in the meaning, have too often been understood to have a close connection with sexual morality, legal and philosophical writers are not always careful to indicate that although the main illustrations of the moral problems are generally taken from the sexual morality, morality remains fundamentally a classification of what is right and wrong. More sophisticated definitions of morality have also been worked out in the debate on the distinctions between law and the morals. Following the utilitarian of the last century, Professor H.L.A. proposes two working definitions of morality: positive morality, or the morality actually accepted and shared by the given social group, and a critical morality, which may be defined as the general moral principles used in the criticism of the actual social institutions, including positive morality. In concluding notes or in a summary, the legal enforcement of the moral value is a complex issue that requires careful considerations of the relationship between law and morality, as well as the practical implications of the legal enforcement. While laws that reflects moral principle can help promote a just and equitable society, it is important to balance these considerations against the need to protect the individual rights and freedoms. So, viewers, that was all for today. We will discuss more topics on the jurisprudence in the forthcoming videos. Thank you for watching the program.